Question about this that you're saying.
Yes.
Even though Eddie and Imachiko are all saying that why will the speaker receive a letter and act on it, a letter for which he constitutionally ought not to receive and act on?
Yes.
But this one comes from Olamide about what you just said. He said, if Ngilari cannot benefit from his wrong,
yes,
why then should Fintiri benefit from his own wrong?
Okay, but we are not. But the case of Fintiri is in court already. There is nothing about
for this particular judgment.
Fintiri.
If he had gone otherwise,
yes,
it would mean that Fintiri would have benefited from his own wrong as
yes,
well.
Okay, but then you see, there ought to have been. You remember that an election should have taken place. It should have taken place maybe by tomorrow, this weekend. But the court stopped the election. That's the thing. I mean,
saying there was no vacancy in the first place.
So there was no vacancy. When there was indeed a vacancy, there was a vacancy. So you see, it's not Fintiri. It's not. I'm not saying that Fintiri ought to have been made the governor, but nobody should have been made the governor by the court.
But
no,
again,
that pronouncement is
Akiri,
totally wrong.
Since the speaker,
yes,
you know, by way of speaking constitutionally, flouted the constitution by receiving what he ought not to have received.
Yes.
Doesn't that mean that there wasn't any resignation in the eye of the law? Because if you give me a letter, you're a governor, and constitutionally speaking, I'm not supposed to be in receipt of such resignation.
Yes.
Does that mean you have resigned?
Yeah, but you see, you should probe into the mind of the mind of the person who submitted that letter wrongly. This person is a lawyer, a minister in the Temple of Justice. He knows, he ought to know that upon resignation, and if he decided to resign, he should submit his letter to his boss, the governor, who was still very much there. Why did he choose? Why did he elect to misdirect his letter? That's what I'm saying. Okay. The court ought to have probed into the whys and wherefores of this decision. And I just told you there were two, major reasons which I think must have informed that decision. Number one, he was trying to avoid the odium of impeachment when the two names were there. The governor and the deputy governor were to have been impeached. Then, as at the time that it transpired that he was not going to be impeached, he said, good, so I have done the right thing. Because I have misdirected the letter, and I'm going to claim that I did not resign after all because I misdirected the letter. That's not what the Constitution is saying.
What would you say to those who also claim that the speaker was overly ambitious? Because now, initially, while he indicated interest to contest the governorship elections, everybody thought within his party, wait a minute, you were not even supposed to contest. We didn't see that coming. We just thought you were just supposed to facilitate this process and then let the other persons come on and contest. It then turns out that he eventually, when the party met, said, okay, go ahead, fly the flag, but you will not contest for the general elections afterwards. So it looks as though all this ambition is what was going on.
Yes, you could see with half an eye that there is galloping ambition on the part of one or two of these people. I mean, but now the case...
That's talking about the intention of the speaker.
Correct, the intention of the speaker. But the point here is that the speaker's case is not in court for Justice Adeni Ademola to decide. You remember? That case which Justice Adeni Ademola, decided did not involve anything about the speaker. I mean, if any person...
Other than him receiving, the letter? Or was
other than
the deputy governor not
the letter,
properly...
whether to punish him or not to punish him, to reward him or not to reward him. That case is not in court. They could only say he should not have received, he should not have been the recipient of the letter.
Okay, look at this analogy too.
Yes.
Because others also think, isn't it clear-cut? Because if a letter was addressed to a director in an organization, when it should have been directed to the chairman of the organization, and then the director receives it, knowing that, look, no, this is not meant for me, I can't act on this no matter what you say. Shouldn't they have indicated, well, I'm not the person to do this, you have to properly address this to the appropriate quarters if you want action to be taken?
Yeah, that's correct. That's what we were saying. So when we're talking of a web of conspiracies, That's where
couldn't the court have found that responsibility lay on the speaker to say, well,
he received it when he ought not to have received it. He received it, and instead of advising the man, the deputy governor, now governor, please take it to the appropriate quarters. That's your boss. Read section 306, subsection 5. He didn't do that. So there must have been something. And that's what I said this court ought to have probed into. There was something there. So don't talk of the Constitution and say, there was no full compliance with the provisions of section 306, subsections 1, 2, and 5. Don't say that at all. You know that there was a wrong perpetrated by the deputy governor and maybe some other people. And the case of the deputy governor is
wrong was by the speaker.
No. The first wrong was by the deputy governor, now governor, in misdirecting his own letter of resignation to the wrong authority. That was the first wrong. The second wrong was in receiving the thing, the receipt of that letter of resignation by the speaker when he ought not to have received it.
But didn't the court just consider it based on the fact that was before the court?
I beg you, please come again.
The court would have considered this based on the facts that was presented to them.
Correct.
By their counsels.
That's what I'm saying.
They might not have been saying why they should probe not writing it to the appropriate quarters.
That
case was not before the court as well.
Yes, that's why I'm saying it, that with the profoundest respect, that if they didn't see the way I'm saying it now, that judgment with the profoundest respect was delivered per incuriam, because you can never profit from your own wrong.
No, but was the question of him being dubious about his submission also before the court?
Well, it should have, somebody should have brought it up.
Okay, but since it wasn't...
Yeah, since it wasn't, if
wouldn't you say the court rightly ruled?
Well, but I'm sure that the other counsel...
Mr. Akiri, let me remind you, you recall, leading up to this purported resignation, the governor of Adamawa State, you also recall that we saw it on the pages of the newspaper, making headlines, was nowhere to be found.
The what?
The governor then was nowhere to be found.
Yes. You mean as at what time?
As at the time he took that letter to the speaker, the governor, if you recall, was nowhere to be found. It was big headlines.
Yes, but it can't.
So for the speaker, it was nowhere to be found.
Yes, he can't plead that, because he can't plead that as long as the governor, he ought to smoke all the nooks and crannies of the state and look for him, because the Constitution says you should submit your letter of resignation to your boss, to your governor. So if the newspapers reported that he was nowhere to be found, the deputy governor ought to know where he was. And if he did not know where he was, he ought to have ferreted every nook and cranny of the state to look for him and then say, my boss, this is my letter of resignation. He didn't do that. And therefore, there was an ulterior motive.
Okay, I was just wondering if we could get that Professor Yewo's comment again before we
wrap it up. I listened to that before.
Quite interesting.
Yes, I listened to that before I started my submission.
So, but now they've gone to appeal.
Yes.
And then they thought that, look.
Okay. And I'm so happy they've gone on appeal. I am not aware of that. But if they have gone on appeal, I should be very, very happy, because that will enlarge the coast of our jurisprudence.
Okay, I think... No, I just wanted Professor Yewo's comment, but I'm not sure it can come now. But now that this has gone on, I'm seeing some comments here. Abubakar says Ngilari was not sworn in for his impeachment or resignation without following through the governor. And then Temple says Ngilari never resigned in the eyes of the law, and as it papers equity doesn't help it. Okay, well, I'm not sure I can make sense of that. It says, what if the governor refuses to accept the letter from his deputy? Well, if he tried to submit it to him.
Yes, okay, that would be a different story. If after submitting, and he did not say that. So because this is an if. He did not, the Ngilari did not say that I submitted it to my boss. He refused to take the letter of resignation from me, and that's why I sent it to him. He didn't say that one. And you don't smuggle what a party to a case has not said into the case. You see, so that's the point. He did not even make the effort to submit to his own boss. because there was an ulterior motive.
No, what about because they didn't give him the chance to?
Who did not give him the chance to?
The speaker received the letter.
Yeah.
Because part of the argument there was that they confronted him and forced him to write that letter. And so he took the letter and went to the house.
He should tell that story to the Marines. You know that he wrote that letter under duress. A whole man, deputy governor, then he's not fit to be governor.
What was the game plan? Now he's saying his...
So it's a game plan, and this is what we say should not be rewarded. If there is this ugly game plan, it should not have been rewarded.
But that's if that case was, if that question was before the court.
Yes, that's if that, the question must have been before the court now. I mean...
As to whether or not it was dubiously submitted to the speaker.
Yes, correct. I mean, the other party, if they did not say that, that is the prosecution party. I mean, the other party. Now, then I should be very surprised. And the Court of Appeal is going to listen to the whole thing now. Like I told you, I mean, it's not as if I know all the law about anything. But then the point is that the Court of Appeal should not have any problem declaring this judgment as having been delivered per incuriam. Period.
Okay,
yes.
Well, that's why we had to let it go here. Thank you very much. Mr. Chris Akiri is a legal practitioner, and we've been talking about the governorship position in Adamawa. Now there will be no more elections.
Yes.
At the moment, until the appeal follows through. So does that mean that if the appeal follows through, they go back to status quo?
They go back to status quo.
All right. Well, back after this break. Join us again.